ID. Hello and welcome to ID Redacted, and imagine my surprise to find out that Lauren Matthias has got a stalker. So we'll have a listen to why she withdrew her case, and you can make up your mind. So here we go. It's on 1.25. So if anyone's got any problems with that, let me know.
04055. Can I get counsel to state their appearance for the record?
Dastan Dio for the petitioner.
And
Lauren?
James Dunkelberger, the law firm of Bennett, Dueller, Johnson & Deere for the respondent. And respondent is seated with me, counsel taking brothers.
Thank you. Restate your name again.
James Dunkelberger.
Dunkelberger?
Yes, sir.
So Lauren is
Okay, counsel, before we get going, do you want to proceed by proffer, and I'll ask put your clients and witnesses under oath and see if they'll affirm it, or do you want to call up witnesses, cross-examine, direct examine?
I think witnesses, we would prefer calling witnesses, not proffer.
Okay. We are set for an hour hearing, so use that as you see fit. I notice I did have a motion to allow some witnesses to appear remotely.
Yes, Your Honor, that's our motion.
Are they out of state?
Yes, they are.
Okay.
Petitioner also had a motion to allow one of our statement witnesses to appear remotely. The court granted that motion, I think, this morning, and provided the link. But we did have a request outstanding for other witnesses to appear if necessary.
So you guys would stipulate the witnesses appearing remotely?
I have no objection to that.
Me neither, Your Honor.
Okay.
Your Honor, if we could just revisit the schedule today, though. There are several declarations filed on each side. Several witnesses probably intend to appear today. 1 hour is an awful short amount of time to get this all done. And if we are going to try to do it in an hour with live testimony, could we have some sort of a guidance from the court on how we split that up, or, you know, how our time is to be spent today?
Yeah, you guys choose how. I mean, I'll make it even, that it's 50% to each of you as to how you want to go about it. I noticed that there was several declarations filed in regards to this. Have the parties had any communication?
No, Your Honor.
A little bit of
parties
procedure,
themselves.
yeah.
Since, forgive me, maybe I misunderstood. You mean counsels?
Yeah.
Counsel for party?
Yeah.
Minimal on procedural matters last week.
How come there's been no effort to resolve this? Is there a reason why?
Well, from my perspective, it's not that we're against that or opposed to that. It's just the timing of it that's so short between when the injunction was filed and when he appeared. And so there's been a lot of evidence and other briefings to submit and worry about. So I would just say it's only because we haven't had a fair chance to do it.
Okay.
Mm-hmm.
Well, let's go ahead and get started, unless you guys think that some discussion, I can give you a little bit of time if you want to go out and discuss. I think that would be fruitful. Otherwise, we'll just get going.
I'm happy to go out with this then and try to have a quick discussion.
Okay, why don't you guys do that, and then come back in and let me know.
Okay.
About 5 minutes, 10 minutes?
Yeah, 5, I mean, you can tell if we're making progress. As soon as you can see that we're going one direction or the other, let me know.
Thank you.
Okay, they're going out to see
You may have
if they can resolve it.
Okay, counsel, what were we able to work out?
Unfortunately, Your Honor, we're not going to be able to come to a stipulation today.
Oh, dun.
Let's go ahead and, are you ready to proceed then?
We had one matter of housekeeping, Your Honor, from the petitioner, if that's all right, if I may.
Go ahead.
So,
Lauren?
given the nature of the claims and the emotional distress it's caused my client, and considering the audience we have here, my client is requesting that only the necessary parties, those from the respondent's side who will be testifying, be allowed to be in the courtroom, to provide her some sort of safety and comfort during these proceedings, to the extent we can.
Okay. Mr. Dunkelberger?
Yes, Your Honor, we'd object to that. This is a petition that's been brought by petitioner. She's going to be here in the courtroom, and as respondent, Ms. is entitled to have people here with her.
Yeah, it's an open courtroom. There's no motion filed to close it.
Yeah.
So, and
It's
I expect the parties to be here in person when we have a case, so that motion is denied. Now, as to the reality of where we are, how much time does counsel think that realistically you're going to need in this case?
Well, we need at least 2 witnesses, three including the petitioner's husband. I'll try to get through them as quickly as I can, but there are
How
some
much time are you
lines.
anticipating?
Well, Your Honor, I had anticipated having the whole day, honestly.
all day.
Or at least half the day.
Notice go out.
This was continued, if I remember correctly, it's scheduled for last Friday afternoon.
That's correct, and then it was rescheduled to Monday, the 17th to the 27th.
So I'm not sure why when we scheduled it at 4, why you'd anticipate you would have a half day or a whole day.
You're right, I might have misread that, read too much into it, but it was rescheduled for 11 a.m., so
So how much time are you anticipating? That's,
hours,
how many hours?
at least 3.
On your case in chief?
Yeah.
Mr. Dunkelberger?
So we were prepared today because of the short time frame to proceed primarily by proffer. We understood that that's what was going to happen today, given the short amount of time. Brief opening statement, proffer the witnesses, some cross-examination in a hurry, and then be out. We are prepared to accordion to the court's convenience on this. Certainly, if the other side's entitled to 3 hours, we'd ask for parity, but we think that you could do it in substantially less time. It just depends on how they want to do it.
Christine's.
Okay.
I have a suggestion, Your Honor. Pending before the court is our ex parte motion to enforce the temporary substocking injunction. Perhaps if we proceeded to resolve that motion, that may resolve the entire matter. If, in other words, I guess what I'm saying is perhaps we can achieve what we need to by simply ruling on that motion, and then if it's granted, then that resolves the issue, and if it's not, then we can, I guess, readdress and plan at that point.
Mr. Dunkelberger?
That's the tail wagging the dog, Your Honor. I mean, we have 28 days, from the notice. As far as I'm aware, I don't think the court has issued a hearing. I know there was a request to expedite it. I didn't really see grounds to expedite it. There's some pretty serious allegations, and frankly, we were expecting it would go the other way around. If today the temporary order is not extended and made permanent, then that's going to make the court's resolution of that issue a lot easier.
Well, it'd also make it moot, because if let's say I ruled in favor of your client, Mr. Dale, on the motion to enforce, and then later I ruled that there shouldn't have been a stocking injunction, well, I guess I can go, because there is an ex parte one in place. Okay, have a seat. Let me think through something. Thank you for your arguments.
Your Honor, may I respond to one thing he said?
Sure.
Thank you. The temporary one was issued, and it was effective, and there were violations of it. Whether or not the court decides to continue that and issue a permanent stocking injunction is a separate question. So I would argue that we can proceed on just the ex parte motion today.
But didn't I just see a request to submit just barely filed on 9/17? So just 5 days ago?
I'd have to check the date myself, Your Honor.
Yeah, that's what I saw. So I do think that there is preparation time. We do have to give due processes today. If they weren't prepared to argue that today, it's not fair to throw it on them and put that in there. Let me just look at a couple things here.
Your Honor, I'm just going to grab my client.
Did everyone hear that? Oh, God.
Okay, council, here's what I'm going to suggest we do. In light of, it doesn't sound like, typically on these, we have limited witnesses or they proceed by proffer. And it doesn't sound like either party, well, it sounds like one party is willing to proceed by proffer, the other wants to call witnesses. And we certainly do not have enough time to do it today, to get everything in. So what I'm suggesting is I'd like to set this for October 16th. And in that time, I could give you, I can't give you the whole day, but I can give you a good portion of it. Does October 16th work?
Counsel for petitioner is available that day, but my client's still checking.
Checking if Lauren will be available that day.
It works schedule-wise, but I'm going to object.
Okay, Mr. Dunkelberger, I heard you say you're going to object. Go ahead and state your objection.
Yeah, just for the record, thank you, Your Honor. It was noticed for today. We asked for a stipulated continuance. We didn't get it. We moved for continuance. It was continued 3 business days. We have witnesses here from out of state to be sworn in to testify regarding their affidavits to proceed by proffer. It was scheduled patently for an hour. If counsel was unprepared to present petitioner's case within the time allotted, then it's sort of incumbent on him to contact the court and to determine how much time would be available. In the meantime, my client's civil rights have been severely impeded by a temporary order. We'd like to have her day in court. A continuance of almost a month severely prejudices her. We've got that's recalling witnesses that have come from out of state. And we prepared because the court told us to be in court today, and we prepared for the time that the court had to give us. And it's simply prejudicial and unfair to respondent to have it continue at this point, particularly when counsel had every opportunity to stipulate to a continuance and make sure that the court would have time to hear hours of testimony. And that's our objection, Your Honor.
How many witnesses do you have from that state?
We have 2 here today.
Okay. Mr. Dale, do you want to respond?
Yes, thank you, Your Honor. I don't think it's fair to put that on us. I mean, the hearing was set for 11 a.m. I'm sorry, but there was no mention or notice that it would only be an hour. I apologize, but we were prepared to examine many witnesses to prove our case. Counsel had the same information, got the same information we did. For him to assume that he could call in witnesses today to examine them all in an hour, I mean, it's equally to blame. That's not a reason for to say that he was prejudiced. So, Your Honor, I guess I defer to the court on that. But,
Okay, here's what we're going to do. What I'm going to do is we're going to get this on the record. We've got 2 out-of-state witnesses. I'm going to bring their testimony. I'm going to have you put them on the stand. We're going to continue this for the morning of October 16th. We're going to put these 2 witnesses on the stand right now, and we will let them testify. You can cross-examine them. Everybody should be prepared to do that because we've discussed it. And then we can, because your argument, Mr. Dale, is, hey, we were planning on putting on all witnesses today and have them testify in cross-examination, so there shouldn't be any preparation issue there. You've indicated you're prepared, Mr. Dunkelberger, to move forward with those 2 witnesses. So let's put those 2 witnesses on the stand, and we'll continue this until October 16th, beginning at 8:30, and expect that it will be done by 3 o'clock on the 16th. Sounds like that did work for everybody's schedule. Okay, any questions?
no, Your Honor.
Okay, Mr. Dunkelberger.
Yes, thank you, Your Honor. We'd like to call Janice to the stand, please.
The first witness,
Please stand right here.
Janet.
Raise your right hand. Do you solemnly swear the testimony you're about to give and the matter before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Go ahead and have a seat.
Miss, could you state and spell your name for the record, please?
Yes, it's Janice.
Okay. And Ms. President, anticipation of today's proceeding, did you submit a declaration to be filed with the court?
Yes.
And did you have the opportunity to review and comment on the declaration before it was filed?
Yes.
Were you able to correct or modify or draft or otherwise comment or contribute meaningfully to this declaration?
Yes.
Did you authorize signature of this declaration?
Yes.
And did you understand that when you did that, you did it under penalty of perjury of Utah law?
Yes.
And do you certify here today that the declaration is correct to the best of your knowledge, information, and belief?
Yes.
Just by way of a quick review for the court, could you please tell us your relationship with respondent, Ms.
I met her in April 2024 at a trial, and we became friends. And we have continued to be friends and attend other trials together.
Okay. How would you describe your relationship with the petitioner, Lauren Mathias?
I met her, well, we were in Facebook groups for a different case, and I met her in April 2023, but we were never friends.
Has Ms. ever asked you to contact Ms. Mathias?
Never.
For any reason?
No.
Do you understand that by discussing your declaration here today that it's going to proceed by way of proffer and it's going to take the place of your testimony on direct examination?
Yes.
And with that, Your Honor, I'll yield my time.
Thank you.
Just a clarifying question. I wasn't clear on when you met my client.
I met her at a trial April, I think it was, I'm trying to remember, 23 maybe?
April 23?
I think, well, yeah,
Do you
23.
remember the trial?
Yeah, it was Laura Daybell's trial in Boise.
This is,
That's all I had, thanks.
that was Lauren.
Ma'am, you may sit down. No, I'm assuming no redirect.
No, Your Honor.
Okay, thank you, ma'am.
Yep.
Next witness?
Yes, we'd like to call Lindsay, please.
This is Lindsay.
Do you solemnly swear the testimony you're about to give in the matter before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Ms. Could you state and spell your name for the record, please?
Lindsay. Sorry.
Thank you, Ms. And in anticipation of the hearing today, did you provide a declaration to be filed with the court?
I did.
And did you have the opportunity to review, draft, contribute, or otherwise put your seal of approval on the declaration?
Yes.
And did you authorize me to sign on your behalf and file with the court?
Yes.
And did you understand at the time that your testimony and your declaration could be offered in place of your direct examination here at trial?
Yes.
And do you certify that you understood that you were making the statements that you made under penalty of perjury of Utah law?
Yes.
And are these statements true and correct to the best of your knowledge, information, and belief?
Yes.
Just by way of background and a quick summary for the court, could you please tell me your relationship with Ms. Respondent?
I met Christina in April of 2024, and we became friends and have been friends since.
Okay. And would you please describe your relationship with the petitioner, Lauren Mathias?
I met Lauren Mathias in April of 2023, and we were acquaintances at first, and then later became friends. And then we were friends in April of 2024 when I met Christina.
Okay. Was there any point at which your friendship with Ms. Mathias changed?
Yes.
When was that?
In December of 2024.
And what happened?
Well, I was freelancing, working for her, and that relationship ended. I thought we were still friends. We talked in December. Everything was fine. Then the next time I saw her in person was in April of 2025. And we greeted each other briefly at the courthouse in line for security. Hey, how are you? Good to see you. That type of thing. And I haven't spoken to her since.
Okay. Did at any time Ms. ask you to contact Ms. Mathias for any reason?
No.
In your declaration, you gave some testimony about an incident that occurred at a restaurant in Boise. Do you remember that?
Yes.
And was there any interaction by you personally with the police after that episode?
No.
Okay. Have you reviewed the police report that was generated from that episode?
Yes.
Okay. And you received a copy of it previously?
Yes.
Okay. Do you know whether or not that investigation remains open?
To my knowledge, it's closed.
Okay. And what's your knowledge on that based on?
Based on the police report, the officer talked to the restaurant, maybe the waiter, confirmed that me and my friends were at the restaurant before. We left after, and when the officer put in his report that he spoke to...
Objection, hearsay, Your Honor.
Okay.
Hold on. Let me just... Yeah, she's going to testify anything the officer says that will be hearsay sustained.
Okay, move to strike, please.
Yeah, that's stricken. Any hearsay testimony, the rest of them.
Okay. So with respect to your review of the report, just to repeat for the court, you've
Yeah.
reviewed the report.
Yes.
Okay. Was Ms. present at the restaurant in Boise?
No.
Do you know where she was?
Europe.
Okay.
Objection, foundation.
Sustained.
How do you know where she was?
Because she told me she was going to Europe.
Objection calls for hearsay, or is hearsay, excuse me.
It's an admission by a party opponent. Overruled.
And in any event, she wasn't at the restaurant with you?
Correct.
Okay. Following the incident at the restaurant, or at any other time, have you, on behalf of Ms. ever reached out to Ms. Mathias?
Never.
With that, I'll yield, Your Honor.
Is it okay if I strip one of these wires?
Yeah.
Thank you.
Is it Miss or Mrs.?
Miss.
Miss, I was also confused by your testimony. When did you initially meet my client?
April of 2023.
2023?
Yeah.
Okay. I thought I heard you say 24.
Sorry.
Lawrence, lawyer.
How were you introduced to her?
I don't know. We were both at the same trial, and I might have introduced myself. I was there for work. I knew Lauren to be in that same industry. Just, hi, we're in the same trial, and maybe something like that. I don't really remember.
Okay. How do you know the respondent?
I met her in April of 2024, the next year, at a trial as well.
Okay.
Yeah.
Would you describe your relationship? How would you describe your relationship with the respondent?
Really good. We became friends. Kind of happenstance, but we had a lot in common, and just kind of naturally became friends.
And you're still friends to this day?
Yes.
You communicate regularly?
Yes.
How often?
Multiple times a week.
Do you have a social media account?
Yes.
Do you follow the respondent's social media account?
Yes.
Are you familiar with the account titled Objection, Your Honor?
Yes.
What is that account?
That is one of Christina's TikTok accounts.
You say one of hers. Does she have others?
She has a art account where she posts art stuff because she's like an artist.
Okay. Have you seen or watched, or are you familiar with the videos that are on the respondent's Objection, Your Honor account?
Have I seen them?
Yeah.
Yes.
Okay. All of them?
I don't know if I've seen all of them, but I've seen a majority.
Have you ever commented on any one of her videos?
Yeah.
How many times?
I don't know, maybe 1, 2, 3, maybe.
Okay. In those videos, do you recall the respondent ever referencing to a person as ex-friend?
Yes.
Who is the ex-friend, according to your knowledge?
Objection, Your Honor. Foundation calls for speculation.
Sustained.
So you've seen the videos, and you just mentioned you have seen the ones where she mentions her ex-friend.
Correct.
Okay. Let me ask you, what is your understanding of who the ex-friend is?
My understanding, the ex-friend, to be Lauren Mathias.
That's my client.
Correct.
Okay. How would you characterize the nature of the videos about the ex-friend, my client? Were they positive or negative?
Which videos?
I'm just asking for your overall impression
Okay.
of all the videos you said you've seen.
Overall
were they
impression.
positive about my client or negative, in your opinion?
I don't think they were positive, but
Okay. So you can't say they were positive. Can you think of any video that was positive?
there were actually a few where they weren't about your client. They were about protecting like your own personal peace, things like that, things that were like kind of, I don't know, not like motivational, but like peaceful, like, I don't know if that makes sense.
Okay. Do you communicate with my client to this day?
No.
When was the last time you communicated with my client, to your memory?
The last text messages I sent her were in January of this year. I was asking her to coordinate a podcast collaboration. Those messages were friendly, business, professional, and then the last time I spoke to her in person was in April of 2025 when we briefly greeted each other.
Okay. Did your relationship with my client have any professional nature to it?
Yes, at one point it did.
How so?
After I left one of the jobs I was at, I was kind of waiting for my next one to start, and so we were friends, and I offered to help, and Lauren was very supportive of me at the time when I was leaving the place I was at, and so I worked for her and her husband freelance for a few months.
So you were an employee of hers for a few months?
I wasn't an employee, like, are you meaning legally? So it was like a 1099 contract.
Okay.
If that's what you mean.
When did your employment end?
I believe beginning of December, approximately.
Do you recall any interactions with the respondent? Did you have any personal conversations with the respondent about my client, either before or after your employment ended?
Can you repeat that?
Yeah, can you recall any conversations you've had with the respondent about my client?
Yeah.
At any time?
Yeah.
Okay. How about after your employment?
After? Yeah.
Okay. What was the nature of those conversations?
Can you be more specific? I'm sorry.
Sure. Whenever you were speaking with her about my client, would you characterize it as positive or negative?
I guess I don't really. Can you ask me that one more time? I'm trying to understand.
Sure. I'm just asking if the nature of your conversations you've had with the respondent about my client after your employment ended, were they positive about my client?
All objectives, Flax Foundation, vague.
Yeah, sustained.
Okay. Let me ask you this. How often would you say did you and the respondent have conversations about my client after you left her employment?
Well, at first we were all friends. So in that month of December, things were a little bit awkward between Lauren and I. And so I think that the conversations were based on, are you going to reach out to her? Like, or do you think this is something that can be fixed? Like the friendship. And then after that, I'm not really sure. I am aware of I put in the thing about, like this case. Like I know, like in April, when Christina and Lauren had a conversation, like I knew about that.
Were you aware of, let's see, when did you become aware of the respondent's social media account about my client?
I'll object. Assumes facts. Flax Foundation.
She's already testified she's seen and reviewed all the videos and the knowledge of the accounts.
So what the testimony I heard is that she's aware of some communication there, whether it was on the objection, Your Honor, a TikTok account, and that she understands that the ex-friend referred to there was referring to the petitioner. So if you want to ask her about that specifically, or if there's others you can ask, otherwise the objection is sustained.
Okay. Do you recall speaking with the respondent at any time about her social media account titled Objection, Your Honor?
Yeah.
Describe that first, when you first became aware, please.
I don't really remember. I think I would be guessing. I'm sure it was probably, I don't recall specifically.
Do you recall if the respondent alerted you or made you aware that that channel existed, or did you happen upon it on your own?
I can't remember.
And you don't remember the first time you watched a video on that account?
Oh, no. I can't remember if she told me about it or if it popped up on my page.
Okay. Are you, let me ask you this. So, do you know approximately how many videos are on that account?
No.
Okay. I'll represent you. There's over 50. Okay.
I'll object to the representation.
You can represent that. I just want some clarification. 50 of what? 50 total videos? 50 videos allegedly referring to the ex-friend? What are 50?
Thank you. There are over 50 separate videos or posts on this, my objection, Your Honor, account referring to the ex-friend and discussing some of her private details of personal conduct.
Your Honor, I object to that. That's a fact in dispute in this case.
Hold on. I understand your objection. What you can do is you can ask her if she understands that there are 50, if that would surprise her. If she doesn't know, she doesn't know.
Okay. Have you seen all the videos? All of them?
No, I haven't watched every single video.
Are you aware of about what time they began?
Yeah, I think so.
Okay, what's your recollection?
Maybe in June,
Okay.
maybe?
Was this before or after you ceased working for my client?
After?
Okay. So, to clarify, the videos began popping up on this account, to your knowledge, after July of 24?
25.
25, excuse me.
Sorry.
Okay. Did you have any involvement in making or creating those videos?
No.
Okay. Are you aware that there's a second social media account titled the same objection, Your Honor, on, I think it's Instagram?
Yeah.
Okay. Have you seen those videos?
I don't know.
Okay.
I'm not sure. Maybe.
Maybe. All right.
I can expand on that if you want a little bit, but
Sure, go ahead.
so because I do other people's social media for work, I'm not typically logged into my own social medias. So when I do log on or switch accounts, like I kind of can't remember because I don't do it that often. I kind of don't really like social media for myself because I work doing it, so I can't recall.
Okay.
That's what I mean.
That's all right. I'll move on.
Yeah.
Let me backtrack just a little bit for sake of time. To your understanding, based on your conversations with the respondent, who's your friend, who you mentioned you communicate with several times a week, you said 2, what is your understanding of the purpose for which those accounts were created?
What's my understanding of the purpose of why those were
Why
created?
did the respondent make those accounts? Do you know?
I think because her art ones had like 50,000 followers on it, and she didn't want to put that on her art feed.
Put what on her art feed?
Other videos that aren't about art.
Other videos about who?
Other videos that aren't about art.
And what were the videos that weren't about art?
I'll object as asked and answered.
Well, and that would have been accurate before you asked this most second question, but I think the second question is appropriate to overrule.
Can you repeat that? I'm sorry.
Sure. You stated she has another, the respondent has another art account that she uses for art. I was asking you so you said she has another account she wanted, why did the respondent, to your knowledge, create a separate account titled Objection, Your Honor?
Now that has been asked and answered. She said so that she didn't intermix, she's got her art account, she didn't want to run this other stuff on the feed. The question that, the second one you followed up with was, what are the other posts or videos she's putting on the other account?
Thank you, Your Honor, for that. That's correct. So what are the other posts that the respondent made?
The other posts
That
on...
you referred to other posts that she didn't want on her art account.
Oh,
what were those videos about?
Those videos were Christina talking about her life, things going on in her life.
What was
and-
going on in her life at that time?
I'll object. Lacks foundation. Calls for speculation.
To your knowledge.
Hold on, I'm going to sustain that objection. Go ahead with the next.
Okay. Do you have, well, I'm just asking you, what do you understand those videos on her other account to be about? Or, excuse me, let me rephrase. Why did she create a separate account specifically for these videos? You mentioned she didn't want these videos on her other account, on her art main account, whatever. What is your understanding of why she created a separate account about other videos?
So I actually didn't really understand that part either. Like, I don't know.
Oh, no.
I don't know why she created a second
No,
account.
wanting to.
I just assumed it was because she didn't want it on her art account. I'm not sure. I don't think we had a conversation of that, so I'm not sure.
Okay.
Did I answer the question? I'm sorry.
Well, I think you have. That's all I have.
Unbelievable.
We're out of time, Your Honor. Very briefly, direct here. The posts that you saw, did they contain threats?
No.
Did they name Lauren?
Hold on. I need some foundation. What post?
The posts that you were discussing, that you said that you saw
Yeah.
on these accounts?
On the objection, Your Honor, counts?
Yes, Your Honor.
Okay.
0.
Okay.
I'm going to object to legal conclusion, Your Honor, about threatening, what constitutes threatening language.
Okay. Overruled.
Did they refer to Lauren by name?
No.
Did they depict Lauren by photograph with her face showing?
No.
Have you ever threatened Ms. Mathias or her associates?
Never.
Have you ever purposely stood in their space in order to menace them or intimidate them?
Never.
Have you ever seen Ms. MacArthur stand close purposely to Ms. Mathias to threaten or intimidate her?
No.
You mentioned some conversations that you had with Ms. that were about Ms. Mathias.
Mm-hmm.
During those conversations, did you ever hear Ms. MacArthur threaten Ms. Mathias?
No.
Did you ever hear Ms. MacArthur talk about encouraging someone else to threaten or menace Ms.
No.
Mathias? Those are all the questions I have, Your Honor.
Anything else?
Okay.
So, Your Honor, if I may, based on the foundation that's in the Janice declaration, I'd like to move for the admission of defense exhibits 11 through 13. Foundation's been laid, and we'd like the court to receive those.
What are exhibits?
Yes, Your Honor. So there's one photo that depicts some of the people that are referenced in the declaration. There is the Boise police report, defendants 12, and then there's also a video that shows a proximity issue that was raised in Ms. Mathias' declaration.
Response?
Your Honor, I'm going to object. I haven't had the opportunity to review any of these videos. They haven't been produced or presented here today. The declarations themselves have been produced, but they were only produced on Friday.
Your Honor,
So I would object to them being introduced at this point.
I sent counsel a copy of the videos. We actually sent a link to their, we sent a link to our exhibits within an hour or so of receiving their exhibits for the first time. And so, yeah, these have been provided ahead of time. They've had the opportunity to see
By ahead of
them.
time, you guys both exchanged exhibits on Friday?
Yes, Your Honor.
Yeah.
And we that's the first time that we had received them as well, even though they're referenced in the August declarations. And so again, that's done in anticipation of trial. If you'd like me to play for the court or show the court the exhibits, I'm happy to do so, but they should be admitted at this point.
What's your objection? Do you have a foundation objection, or is it just that you think you didn't see until Friday?
Well, I don't know what the videos are, so I'm not sure if they lack foundation.
Did you review the declaration?
I did. I have not received any videos contrary to, or any I haven't received the evidence that he claims to have produced. I haven't seen it in my inbox. I haven't seen any notices filed with the court. They were produced.
Your Honor, I'm happy to provide the email that we provided Mr. Dell.
In any case, even if they were provided, it was just last Friday. I haven't had a chance to review
Yeah,
it.
this is the problem with the cramming that's going on. We do have some real due process issues. First of all, are we done with Ms.?
Yes, sir.
Let me sit down, thank you. I'm going to withhold admitting those right now, and you can make that motion again when we motion to admit. I don't know that we need anything else from this. You're relying on our declaration to lay foundation. So I'll withhold admitting them. Are those that you guys can sit down? Are those the two witnesses we need today?
Yes, Your Honor. Just revisiting that issue, though, I mean, the issue that I'm having is I'd like to make a motion to dismiss the temporary restraining order today. Again, almost a month is a long time for a temporary order to last, and I think that particularly Defendants 12, the Boise Police Report, is really central to the way that Ms. Mathias obtained the temporary order in the first place. She represents...
So that's going to be hearsay. I mean, let's talk about that. That's one of the things. That police report is hearsay, and her testimony doesn't get you past hearsay.
Well, so her testimony can lay... And if you like, I can absolutely lay foundation for how she received it. It's a business record. The police have kept it in the ordinary course of business.
You don't have an officer here.
This is a civil proceeding. That's right, but she can testify that she received it directly from the police along with the other videos and things that the petitioner submitted. And with that, it's kept in the ordinary course of business. It is a police report, but
she couldn't lay foundation. And you might look at it, she can't lay foundation that it was kept in the regular course of business. She's not the records keeper for the police department. And really, let's go to your primary point. I don't want to get caught up on that. Your primary point is that you've got some issues with the temporary stalking injunction being extended during this time period. And from your arguments previously, it seems like your client's primary concern is that this impacts her ability to make a living.
Yes.
And her free speech rights.
Yes, Your Honor.
Talk to me about the free speech rights. How does this impact her free speech rights?
Yeah, so with that, Your Honor...
And I read your case law. I want to know factually what in the stalking injunction prevents her from saying what she's saying. Go ahead.
Sure, Your Honor. Well, so, and we don't believe that it does, but petitioner has alleged that by posting videos, again, without using the petitioner's name or her likeness, that she has violated the temporary order. Now, the amended temporary restraining order does say to keep off online. The respondent understood that to be do not contact her on TikTok, do not contact her on Instagram or on any other platform. The allegation is simply by referencing, making a post that's related to the petitioner online, that she's somehow violated the temporary order. There's 3 videos that they claim have already violated it. That's 3 of the 6 alleged violations that they're prepared to talk about today. And so there's got to be some clarity there. That just doesn't jibe with Towner or with Fischler. Certainly the First Amendment allows talking to third parties or the public about somebody. That's Towner v. Ridgway. That's been the law for a long time. Fischler reiterates it. It's just plain letter law in Utah. She hasn't communicated through these posts to or specifically directed at the petitioner. And for that reason, I mean, she's basically gagged online at this point, according to petitioner. Now, we're hoping that the court determines and agrees with us that you can't interpret the amended temporary order that way. But certainly they've alleged that on the language on its face that she's not allowed to go online and to post anything related to the petitioner. And obviously that's got First Amendment issues. And practically it's unfeasible. Everybody goes online and everybody can comment with their friends. Instagram, TikTok, those are ways that we communicate these days, and certainly Ms. is entitled to communicate to her friends and followers via these online platforms. And it's simply unfair to go another 3 weeks just allowing petitioner to collect videos that have been posted that are First Amendment protected and bring them and use them as a cudgel when we get finally to court for the full hearing, which we thought was going to happen today.
Okay, thank you. Go ahead, response.
I have to object to the characterizations he's made on behalf of myself or my client and our positions. The evidence, like we're getting lost in weeds. The motion he made was based on the declaration, the testimony we've heard in the declarations, that the court should suspend the temporary order. But there is no evidence to suggest that. Like, that's not the question. The question, Your Honor, is whether or not my client has the burden to prove that it should continue. There's been no motion to set it aside at this point. So that's improper. That's not properly before the court. The rest is just argument and representation.
Why would he file a motion to set it aside if he thought he had a hearing today to deal with it in full?
Well, I'm just saying procedurally. There are procedural ways to do that. Those haven't been met. Satisfy the other arguments about what's been said online or what they're about have yet to be proven and shown. Virtually all of what he said is not based on evidence that is before the court today. So the court can't make that ruling today.
Okay, thank you. Go ahead.
Yeah, and with that, Your Honor, this is a motion, and we're making it. We learned minutes ago that this is going to be extended for another 3 weeks, and this severely impacts respondents' civil rights. I mean, this is what we have. I mean, at a minimum, we need a clarification for the amended temporary order that that makes clear that she's entitled to go online and talk about whatever she chooses to talk about online, and that certainly can't be a gag order that it has extended, that we're going to be on for a motion for sanctions about, and then that's going to go for another 3 weeks now.
Your Honor, I would object to the characterization of the language of the civil stalking injunction itself. It's not what he represents it to be.
Well, I'm reading it,
So
and it's my order, so I'll make the interpretation of it.
Sure.
Okay. I do have, I'm not sure how this was interpreted, but let's go back to the purpose of an ex parte temporary order. That is to stop any harm. Specifically, we're looking at ongoing threats or physical harm that could happen. It's made without all the information. It's made simply, basically from one side, providing the information. As the ex parte order right now, it prohibits personal contact and prohibits threatening, annoying, stalking, harassing. That will remain in place as is. As to the no contact order, that will remain in place. Specifically, as to the text, mail, email, or any other communication directly or indirectly. In other words, I don't want them talking to each other. Now, it does identify other people and family members for sure. So Mr. Mathias is sure going to be covered by that. As to Grace and Yor, is there any reason that your client would need to contact Mr. Yor?
Ms. Yor, but no.
Oh, excuse me, Ms. Yor, thank you. Okay, then Ms. Yor's included on this. Son is covered by this. So that will remain in place as well. As far as the stay-away order portion of it, stay away from her home, that will remain in place as well. Is there any reason why she would need to go to near a job site or a school of Ms. Mathias?
Well, no, but just to clarify, I mean, there's public places where they both
I'm
make.
going to deal with that.
Okay, so no, not in Henderson, Nevada.
Okay. And then I think this is the provision that may be misinterpreted here, that she's prohibited from online forums and social media accounts. But that was in kind of a, in parentheses, TikTok, but then it says down there the 2025 CrimeCon Expo that was in Denver, Colorado, September 5th through 7th. When I was reviewing this, that was what I was looking at, was that CrimeCon. I in no way intended that the respondent was to be kept off of social media sites. I do think that's freedom of speech issues, and I don't think that this order was intended to cover that. So she can get on those. Now, I guess she runs the risk if she's on those and those are interpreted as annoying or harassing, although I will say that's a fairly high bar in the sense of just because somebody says something you don't like, that's not going to be a violation of a stalking injunction. And there would have to be directed comments that were clearly meant for a specific purpose. Yeah, but, you know, there was, in obtaining the order, petitioner made some allegations that she had strong belief that she was in immediate danger in relation, again, to the CrimeCon that was in Denver, Colorado. Now, as to the work environment, it does sound like the parties may attend similar court hearings. I'm assuming court hearings. Is there any other public buildings where they need to be in the same spot?
Well, the accompanying press conferences and other kind of public places is what we're talking about.
Okay. As to those, I do think that this order is not intended to stop Ms. from working.
So I would object to that characterization, Your Honor. Sorry, the respondent doesn't work at courthouses. She's not a criminal investigator. My client is. So the representation that they need to appear in public, they may appear in public places based on her employment is not accurate. She has no
Lauren
employment.
works in them.
I think it's not disputed that they're public places. It may be in dispute whether they consider her to be a professional in this field. We certainly do call that a disputed issue, but it's not disputed that they're public places.
Yeah.
What does she do?
She takes photos.
She's a photographer?
Yeah.
She's not a photographer for the court?
Hold on.
Sorry?
Well, that's true. She's a freelance photographer, and she also is, like everybody, trying to make her way in this true crime industry.
Well, then I have freelance work.
Okay, that's right. She does freelance work for some national news outlets you would have heard about.
Okay. Yeah, let me address the public place argument first. That doesn't fly because stalking injunctions often cover public places. However, it does sound like she has a right to be there and she's got a purpose for being there. And if that's the case, if she's there with a purpose, then she can be there. The order is that they will keep, that she will keep her distance because Ms. Mathias, she's not a respondent, there isn't a counter one. So Ms. is required to keep her distance from the petitioner. Now, it's hard to say exactly how far that is because it may be different if we've got a media scrum or something and we've been taking photos, then it may be closer. But she certainly cannot be right next to her. She certainly can't be making faces to her. She can't be making gestures. She can't be making comments. None of that can occur. If they're in a courtroom, like a courtroom here today, I'd expect that they would be on opposite sides of the courtroom. So I expect to receive a modified temporary civil stalking injunction with those changes incorporated.
Your Honor, if I may, I'm sorry. There is actually one more place where the online stuff and the social media, way down at the bottom with other relief sought, is actually where I was quoting from earlier, where it says that she's not allowed to post relating to or referencing petitioner. And that's, I think, one of the things that we need to clarify.
Where it says respondent shall cease and desist any and all online activity and communications relating to or referring to the petitioner her immediate family and extended family members.
Is that portion subject to the court's clarification on the other bit that you just made?
Yeah, now I think that was clear before, that I expect her not to post anything necessarily that she's running a risk. If she posts something negative about her, that's something she can, I guess, theoretically do. But she needs to be careful in walking that line.
Is there any clarification you could give us on what might be qualified as negative?
Well, if she's threatening her, again, we have to go back to the purpose of a stalking injunction. If she's threatening her, if there's a harassment that would cause emotional harm. I mean, all of us run the risk that somebody's going to say something bad about us. Whether that turns into harassment is, I think that's a high bar.
Is there any
Let me be clear on this, Mr. Dale. This civil stalking injunction was in no way meant to silence what Ms. is doing. And I want to be very clear on that. And any permanent stalking injunction will not be for that purpose. That is not what a stalking injunction is for.
There we go.
I guess I'm looking for clarity on what it is the court is basing its ruling on when it says what she does or what she's doing. And
What do you mean?
so the respondent isn't a true crime investigator. She's a photographer. She has an art channel on Instagram. She has separate media accounts, social media accounts that discuss solely the flaws of my client, to air them, to cause her harassment. I guess I'm not sure that, but we haven't had a chance to provide all that evidence yet, so we'll do that at the next hearing. My concern, though, is that based on just the testimony today, that has not been challenged or refuted, and so there is still an outstanding concern that the activity we've alleged that is happening online and in person and to other contacts has not been refuted properly and is not.
Yeah, and I'm not making a final ruling. I'm making a temporary order.
So if the order is to remove this online protection from specific directed, harassment, embarrassing things that would cause my client emotional distress, I guess that's what I'm looking for clarification on. Is the court withdrawing that based on something it saw today? Because there isn't anything we've seen today.
Well, I think what the court is looking at is we're trying to get more clarity than a one-sided order that was initially signed. That was based on one-sided information.
Sure, and we don't mean to interfere with her public or First Amendment rights. But to the extent she has made specific channels titled Objection, Your Honor, that are about my client, we would ask that protections or restrictions on those accounts be held in place until we can
That
have
seems to be directly a freedom of speech issue.
They're directed at my client.
Right, which is a freedom of speech issue. You can say things about people. We may not like them, but we can say things. What she's prohibited from doing, let me be clear, because you're asking for clarity. She cannot threaten. She can't threaten her physically or her family. She cannot defame her. If there's a defamation, then that's something that's illegal and would fit under a stalking injunction. I think that's what we're looking at is that she can't do.
I can represent to you that there are many, many videos that defame my client.
Okay.
So I would ask that temporary protection be in place until such time as we can review, the court can review the defamation.
Well, I think what I'm going to do is I'm amending it, saying that she won't threaten. We're going to be very clear online. She won't threaten. She won't defame. Okay?
Thank you. Whether online or otherwise.
Well, she's not talking to her in person. I expect zero communication.
Yeah.
As far as she can't talk to her, she can't email her, she can't text her. Mr. Donkelbarger, I want to be clear. She can't do that through a third party. She can't send a message through a third party. There is to be no communication there. The other parts of the civil stalking injunction remain intact as well. I don't want her near her house.
Does the 500 feet specifically remain?
Yes.
Oh, thank you.
Yeah, no, as to her house. Now, like I said, the only exception to the 500 feet is if they're in a public space that they cannot be 500 feet apart. And then I expect them to be as far apart as reasonably possible. That's language I want in there, Mr. Dunkelberger.
Yes, Your Honor.
But otherwise, that is 500 feet. So Mr. Dunkelberger, if they're in a mall, your client needs to move away 500 feet. If they're in a restaurant and if your client comes in second, then your client needs to not go in and needs to leave.
What if it's the other way around? What if she was there first?
Well, and why would your client go in if she's worried about her health and she knows her there?
That's the key. If she didn't know she was there, but the respondent says, well, I was here first, what should my client expect to do in that circumstance?
Well, I would expect if your client is worried about her safety, when the reason we got a stalking injunction, and she goes in there, she would leave. Now, if by chance we've got Ms. McCall is in there, I'm assuming your client's not going to go over and approach her. I'm assuming Ms. McCall is not going to approach her and that she will leave, provided she's finished her meal. But I expect that there would be no communication, there would be no, again, facial gestures, anything of that. They'd finish their meal, they'd go on their way. we got to be careful how we're using the tools of the law in this courtroom. And I expect the parties to use common sense. Okay, Mr. Dale, anything I missed on you that you want else address?
Let me review the language, Your Honor. Oh, these clarifications you're making, I assume they apply also to the other protected individuals, her husband, her son,
Yeah,
or
went through that, yep.
Okay, I think we did. Professional associates, other known professional associates of my client. Can we retain that
She's
language?
they're not covered under this list. So no, so you can have contact with them. What I did prohibit is third-party communications. You can't send a message through one of them.
Understood. With respect to,
Go ahead.
sorry.
Finish up.
With respect to the online posts, I think that's the biggest concern for my client. In addition to defaming statements, is there any other clarification the court can give on what would constitute a defamatory statement? So that there's no argument. So there's no like.
What's legally defined as defamation? It's got to fit the legal definition.
Okay. What about harassment?
I don't know what that's going to qualify as, and I can't get into everything. I would say, Ms. MacArthur, I'd be careful in the way you do that. But again, if she's just saying negative stuff, this is not, again, a stalking injunction is not a remedy for shutting down speech that a person doesn't like somebody saying about it. And it seems like that's what you're trying to do in this case.
Well, again, Your Honor, I would argue that we're not asking to restrict her speech. She can still go anywhere else.
That is speech. Online speech is every bit as protected as anywhere else.
Some forms of speech, like threats and defamation, though, are not protected.
And that's what I put
And if that's the best we can do, like that's most clear we can be, I understand. I just wanted to ask for any additional clarification you can give.
Lauren.
Be instructive to both parties.
Lawyer.
Yep. Okay, I think I've been clear on that. Mr. Dunkelberger, anything from your side?
No, thank you, Your Honor.
Okay, with that, we'll plan on seeing you. We've got the two witnesses. I will just save the time. Outside of the parties themselves, if you've got out-of-state witnesses, they can attend virtually unless they're going to be presenting hard evidence. In other words, documents or some other type of physical evidence. If they're going to be doing that, I want them here because it gets real confusing with the technology. And so other than that, if they're out of state, they can appear remotely.
Thank you.
Thank you, Your Honor.
Okay, we will be in recess. Thank you. All rise.
All right. That was the hearing. Thank you to, let me have a look, PNW Step. And it was just funny in looking at, you wonder why Lauren has done work on her face. And just have a look at Christina. She's beautiful. And not saying that Lauren wasn't or isn't, but just might be the reason she started getting all the face work done. So that's just what I've noticed while I was sitting through the hearing. Everyone with Jay has been doing great videos on her on this schmozzle of hidden shoe crimes 9-hour video. So you make up your mind. Again, all opinions are worth it. It's just funny how it's playing out with this Mormon crap on the side. And, anyway, we'll see what everyone else has to say. Thanks for joining me, and good luck and stay safe.